Closed corporation versus special corporation. So what are their main differences? In closed corporation, the classification of corporation may be stock or non-stock, while in special corporation, educational corporation may be stock or non-stock too. However, in religious corporation, it should be non-stock only. The purpose of closed corporation is mainly for business, while in educational corporation, it is for education, and in religious corporation, it is also for religion. The governing laws. In closed corporation, it is primarily governed by Chapter 12, Sections 95 to 104 of this code, suppletorily governed by other titles of this code. While in educational corporation, it is primarily governed by special laws and by general provisions of this code. And also in religious corporation, it is primarily governed by Chapter 12, Sections 107 to 115 of this code, suppletorily governed by general provisions of non-stock corporation of this code. Now, the management. Closed corporation stockholders may assume the management functions. In such a case, the concerned stockholders must perform the duties and assume liabilities of directors, while in educational corporation, the management is vested on board of directors or board of trustees. However, in religious corporation, corporation sole is created as a trustee having legal personality to administer and manage affairs, property, and temporalities of any religious denomination, sect, or church. It is comprised by a single person. In religious society, it shall be managed by the Board of Trustees whose members shall not be less than 5 nor more than 15. Now, what are its composition? In closed corporation, number of persons who may own shares should not exceed 20. Now, in educational corporation, for non-stock corporations, minimum number of incorporators and trustees should not be less than 5 or more than 15, provided that the number of trustees shall be in multiples of 5. For stock corporations, the number of directors shall be governed by the provisions on stock corporations. In religious corporation, it may be incorporated by one or more persons. Now, the other salient features. In closed corporation, listing of the corporate stocks in any stock exchange or making a public offering of those stocks is prohibited. Stockholder has the right to withdraw by compelling the corporation to purchase shares, provided that corporation has sufficient assets. The law does not require the existence of unrestricted retained earnings. Any stockholder may by written petition to the Commission to compel dissolution whenever any acts of the directors or officers are illegal, fraudulent, or prejudicial to the corporation or any stockholder, or corporate assets are being misapplied. In case of deadlocks, the parties may trigger the arbitration clause. In the absence of arbitration clause, the stockholder may petition the Commission to intervene and break the deadlock. In educational corporation, the requirement of continuing board the initial trustees to classify themselves in such manner that a term of 1/5 of their number shall expire every year. The trustee shall have a term of 5 years. Now, in religious corporation, corporation sole may deal with properties of corporation by observing the internal rules and regulation of the religious denomination. In the absence of such rules and regulation, corporation sole may only alienate or encumber properties with court approval. Corporation sole may be voluntarily dissolved by submitting to the Commission a verified declaration of dissolution. Now, let's take a closer look on closed corporation. So, what is a closed corporation? A closed corporation is one of whose articles of incorporation contain explicit restrictions on the following. First, number of persons who may own its shares, but in no case exceed 20. Second, transfer of shares. And lastly, the listing of any of its shares in the stock exchange. So these are the main feature, advantages, and disadvantages, as well as the articles of incorporation. Limited number of natural persons who owns the corporation. Corporation is not considered as closed corporation when 2/3 of its voting shares is owned or controlled by another corporation that does not qualify as a closed corporation. Courts must look into the articles of incorporation to find a provision expressly stating the number of stockholders shall not exceed 20. A preemption of shares is restricted in favor of any shareholder or stockholder of the corporation, or the listing of the corporate stocks in any stock exchange or making a public offering of those stocks prohibited. Take note, a narrow distribution of ownership does not by itself make a closed corporation. So these are the advantages and disadvantages of a closed corporation. Advantages are as follows: attractive to business owners who regard themselves as partners. The shareholder may withdraw and compel the corporation to pay for the fair value of his shares, provided the corporation has sufficient assets to pay for its debts and liabilities. The disadvantages are the follows: not attractive to those who want to secure maximum material benefits from the corporation, not only by way of dividends, but also by way of capital gains through shares transfer. It does not require the existence of unrestricted retained earnings. This may lead to a depletion of capital and diminish the ability of the corporation to pursue its business. It is unattractive to creditors. Their buffer against corporate losses may be diminished in case of withdrawal of a shareholder. There will always be threat of dissolution even if the petitioning shareholder does not have the support of the board and or other shareholders. He only needs to establish the grounds set by law. Now, let's go to the articles of incorporation. So these are the contents: a classification of shares of right, the classification or qualification of owning or holding the same, and restrictions on their transfers subject to the provisions of the following section. Second, a classification of directors into one or more classes, each of whom may be voted for and elected solely by a particular class of stock, and a greater quorum or voting requirements in meetings of stockholders or directors other than those provided in this code. There should be a clear distinction between management and ownership functions. First, for ordinary corporation, the law vests management on the directors, who in turn are chosen and elected by the shareholders. Second, the directors and not the shareholders elect corporate officers. Third, each director should promote and protect the rights and interests of all shareholders. Fourth, the shareholder may only vote on special actions of the corporation. Fifth, the directors and the shareholders may only take actions in a meeting duly called for the purpose and with the prescribed quorum. Now, permissible classification of shares and directors, special quorum requirement. The board may be classified in a manner that a certain set of directors may only be elected by and consequently represent a particular class of shareholder. There may be a higher quorum requirements so that all or some classes of shareholders may be represented in shareholders and board meetings. Shareholders' assumption of management functions. Shareholders may assume the functions of directors, including the election of corporate officers. The concerned shareholder must perform the duties and assume liabilities of directors. Shareholders remain insulated from the claim of corporate creditors. They will only be solidarily liable for such claims should they assume the functions of management, breach the duties of directors. Permissible restrictions. Permissible restrictions. Principle of delictus personae is not applicable in closed corporation. The law only permits restrictions based on qualifications and conditions and not on personality of the shareholders. There may be restrictions on transfer of shares but only to first, right of first refusal against offer of a third party possessing prescribed qualifications and meeting the prescribed conditions. Effect of restrictions on third parties. Restrictions are reflected in the articles of incorporations or bylaws and the corresponding stock certificates, subject to the approval of the Commission. This gives knowledge to the third parties in dealing with the corporation and cannot later on claim good faith against their enforcement. This refers to conclusive presumption. Up to the extent of such restriction in the articles of incorporation and upon the approval of Commission, violation of any of the permitted restrictions permits the corporation to refuse registration of shares in the name of the transferee. Registration may only be allowed if all shareholders agree notwithstanding the violation of restrictions, or there is a subsequent amendment of the articles of incorporation removing such restrictions. Now, these are the remedies of a shareholder. The prescribed qualifications and conditions on the transferee and the application of restrictions on the transfer may diminish the ability of a shareholder to sell his shares to the third parties. The shareholder in that case may tender his share to the corporation and exercise his right to withdraw as a shareholder. He may demand to be paid for the value of his shares, provided the corporation has sufficient assets in the books to recover its debts and liabilities exclusive of capital. In the alternative, he may petition the Commission to dissolve the corporation. However, he must establish the grounds provided by law in the exercise of his right. Now, these are the agreements by stockholders. What is the effect of execution of articles of incorporation on the agreement? Up to the extent a specific stipulation is not reflected or is not permitted to be reflected in the articles of incorporation, such stipulation shall remain valid and binding upon the shareholders who are parties to the agreement. It shall survive notwithstanding the execution of the articles of incorporation, provided the same is the intention of the parties. However, the stipulation must be consistent with, and the law does not require it to be reflected in the articles of incorporation. What is the effect of assumption of management or interference with the discretion or powers of the board? The shareholders who assume the functions of management or interfere with the discretion of powers of the board must observe the duties of directors. Further, they must observe strict fiduciary duties to each other and among. They will be personally liable for the managerial acts of directors to third parties or other shareholder if they breach the duties of directors. They will also be liable for corporate torts. However, the corporation may secure reasonably adequate liability insurance to answer for such potentially liability. Now, let's go to the board meetings. So, when a board meeting is unnecessarily or improperly held, the law does not require rigid application of the rules in holding board meetings for closed corporations. A board meeting is necessary or the improper holding of such meeting is immaterial in any of the following cases described by law. A dissenting director who failed to attend the meeting must file with the corporate secretary his written objection immediately after he gains knowledge of such meeting. Otherwise, he is deemed to have ratified the action taken in such meeting. Paper meeting. It is the basis of paper board meeting, not only in closed corporation, but also in ordinary corporations with limited number of shareholders. The absence or improper handling of board meetings relates to the defect on authority of the corporation to deal with third parties. Corporate action may be declared invalid if taken without a meeting, or taken in a meeting improperly held. The same is true even if the presence of the objecting director of shareholder is not necessary to constitute a quorum. The law assumes the views of the absent director or shareholder, if presented, may influence the outcome of the meeting. Now, let's go to the preemptive right in closed corporations. The preemptive right of stockholders in closed corporations shall extend to all stock to be issued, including reissuance of treasury shares, whether for money, property or personal services, or in payment of corporate debts, unless the articles of incorporation provide otherwise. The importance. This code secures the preemptive right of the shareholders in closed corporations. It may not apply in cases provided in the articles of incorporation. Unlike in the stock corporation, the same is true despite the approval of other shareholders representing 2/3 of the outstanding capital stock. Now, the amendments of articles of incorporation. Any amendment to the articles of incorporation which seeks to delete or remove any provision required by this title or to reduce a quorum or voting requirement stated in said articles of incorporation shall require the affirmative vote of at least 2/3 of the outstanding capital stock, whether with or without voting rights, or of such greater proportion of shares as may be specifically provided in the articles of incorporation for amending, deleting, or removing any of the aforesaid provisions at a meeting duly called for the purpose. So these are the requirements. The general requirements on amendment of articles of incorporation apply to closed corporations. However, the law permits a higher voting requirement if provided in the articles of incorporation. The law does not sanction a similar stipulation in an ordinary corporation. So, let's go to deadlocks. So the essence of this part is to provide an alternate solution in case of a deadlock in the absence of arbitration agreement in the articles of incorporation. So what is a deadlock? It is a situation wherein the directors or stockholders are so divided on the management of the corporation's business and affairs that the votes required for a corporate action cannot be obtained, with the consequence that the business and affairs of the corporation can no longer be conducted to the advantage of the stockholders. The Commission, upon written petition by any stockholder, shall have the power to arbitrate the dispute. So what are these powers? These powers are the following: canceling or altering any provision contained in the Articles of Incorporation, bylaws, or any stockholders' agreement; canceling, altering, or enjoining a resolution or act of the corporation or its board of directors, stockholders, or officers; directing or prohibiting any act of the corporation or its board of directors, stockholders, officers, or other persons party to the action. Fourth, requiring the purchase of the fair value of shares of any stockholder, either by the corporation regardless of the availability of unrestricted retained earnings in its books or by other stockholders. Appointing a provisional director. Dissolving the corporation. Granting such other relief as the circumstances may warrant. Now, provisional director is an impartial person who is neither a stockholder nor a creditor of the corporation, or any of its subsidiaries or affiliates, and whose further qualifications, if any, may be determined by the Commission. A provisional director is not a receiver of the corporation and does not have the title and powers of a custodial or receiver. So what are the powers of a provisional director? All the rights and powers of a duly elected director, including the right to be notified of and to vote at meetings of directors until removed by order of the Commission or by all the stockholders. Second, the compensation of the provisional director shall be determined by agreement between such director and the corporation, subject to the approval of the Commission, which may fix the compensation absent an agreement or in the event of disagreement between the provisional director and the corporation. Now, withdrawal of stockholder or dissolution of corporation. So what are the rights of a stockholder? In addition and without prejudice to other rights and remedies available under this title, any stockholder of a corporation may, first, compel the corporation to purchase shares held at fair value, which shall not be less than the par or issued value. Any stockholder of a closed corporation may, by written petition to the Commission, compel the dissolution of such corporation whenever any of the acts of the directors, officers, or those in control of the corporation is illegal, fraudulent, dishonest, oppressive, or unfairly prejudicial to the corporation or any stockholder, or whenever corporate assets are being misapplied or wasted. Now, in special corporation, there are two types of this. So the first one is the educational corporation and the second is the religious corporation. So the incorporation of educational corporations shall be governed by special laws and by the general provisions of this code. So the Board of Trustees. Trustees of educational institutions organized as non-stock corporations shall not be less than 5 nor more than 15, provided that the number of trustees shall be in multiples of 5. The role of them is to classify themselves that the term of office of 1/5 of their number shall expire every year. Trustees elected thereafter to fill vacancies caused by expiration of term shall hold office for 5 years. A majority of the trustees shall constitute a quorum for the transaction of business. The powers and authority of trustees shall be defined in the bylaws. Now, How about in religious corporations? So here, the classes of religious corporations may be incorporated by one or more persons. Such corporations may be classified into corporation sole and religious societies. Religious corporations shall be governed by this chapter and by the general provisions on non-stock corporations insofar as applicable. For the purpose of administering and managing as trustee, the affairs, property, and temporalities of any religious denomination, sect, or church, a corporation sole may be formed by the chief archbishop, bishop, priest, minister, rabbi, or other presiding elder of such religious denomination, sect, or church. Now, in order to become a corporation sole, the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of any religious denomination, sect, or church must file with the Commission articles of incorporation setting forth the following. Letter A. That the applicant, chief archbishop, bishop, priest, minister, rabbi, or presiding elder represents the religious denomination, sect, or church who desires to become a corporation sole. B. That the rules, regulations, and discipline of the religious denomination, sect, or church are consistent with becoming a corporation sole and do not forbid it. That such chief archbishop, bishop, priest, minister, rabbi, or presiding elder is charged with the administration of the temporalities and the management of the affairs, estate, and properties of the religious denomination, sect, or church within the territorial jurisdiction, so described succinctly in the Articles of Incorporation. Letter D. The manner by which any vacancy occurring in the office of chief archbishop, bishop, priest, minister, rabbi, or presiding elder is required to be filled according to the rules, regulations, or discipline of the religious denomination, sect, or church. And letter E. The place where the principal office of the corporation sole is to be established and located, which place must be within the territory of the Philippines. Now, the articles of incorporation must be verified by affidavit or affirmation of the chief archbishop, bishop, priest, minister, rabbi, or presiding elder as the case may be, and accompanied by a copy of the commission, certificate of election, or letter of appointment of such chief archbishop, bishop, priest, rabbi, or presiding elder, duly certified to be correct by any notary public. So, corporation sole. A corporation sole is a special form of corporation usually associated with the clergy. A corporation sole consists of one person only and his successors in some particular stations, who are incorporated by law in order to give them some legal capacities and advantages, particularly that of perpetuity, which in their natural persons they could not have had. So these are the features. A corporation sole has a legal personality separate and distinct from the applicant head or presiding elder. As such, it may lead with properties. It shall observe the internal rules and regulation of the religious denomination, sect, or church on the acquisition and disposal of the properties. In the absence thereof, the corporation may only alienate or encumber properties with court approval. So what can it do? It may purchase and hold real estate and personal property for its church, charitable, benevolent, or educational purposes, and may receive bequests or gifts for such purpose. Sell or mortgage real property held by it by obtaining for that purpose from the RTC where the property is located upon proof that the notice of the application for leave to sell or mortgage has been made through publication or as directed by the court. Now, the application for leave to sell or mortgage. It must be made by petition, duly verified by the presiding elder acting as corporation sole. It may be opposed by any numbers of the religious denomination, sect, or church represented by the corporation sole. So, when courts are unnecessary to intervene. In cases where the rules, regulations, and discipline of the religious denomination, sect, or church, religious society, or order concerned represented by such corporation sole regulate the method acquiring, holding, selling, and mortgaging real estate and personal property, such rules, regulations, and discipline shall govern. Now, the corporation sole acts through the head or presiding elder of the religious denomination, sect, or church it represents. Thus, the successor in office of such head or presiding elder shall become the corporation sole on his accession to such office and upon notice to the commission. Upon accession to office, the head shall be permitted to transact business as upon filing a copy to the commission, certificate of election, or letters of appointment duly certified by any notary public with the commission. In case of vacancy, the persons provided in the internal rules and regulations may temporarily take place of the corporation sole. So this is a special provision that specifically applies to the voluntary dissolution of corporation sole by submitting to the commission a verified declaration of dissolution setting forth the following. First, the name of the corporation. Second, the reason for the dissolution and winding up. Third, the authorization for the dissolution of the corporation by the particular religious denomination, sect, or church. And lastly, number 4, the names and addresses of the persons who are to supervise the winding up of the affairs of the corporation. Furthermore, upon approval of such declaration of dissolution by the Commission, the corporation shall cease to carry on its operation, except for the purpose of winding up its affairs. So, the comparison between a corporation sole and a religious society are as follows. Corporation sole is comprised by a single person, whereas in religious society, it is comprised by a group of persons or religious organizations within a religious denomination, sect, or church. So both of them has a legal personality to administer and manage the affairs, properties, and estate of the concerned religious denomination, sect, or church, managed by Board of Trustees whose members shall not be less than 5 nor more than 15.
Manuel R. Dulay Enterprises Incorporated versus the Honorable Court of Appeals. Manuel R. Dulay Enterprises Incorporated is a domestic and family corporation. The member of its board of directors are the following: Manuel Dulay as the president and general manager, Attorney Virgilio Dulay as the vice president, Attorney Plaridel Jose as the secretary, and other members are Linda Dulay and Celia Dulay Mendoza. So the corporation owned property known as Dulay Apartment consisting of 16 apartment units. Now, Manuel Dulay, by virtue of Board Resolution Number 18 of Petitioner Corporation, sold the Dulay Apartment property to private respondent spouses Maria Teresa and Castrine Veloso. Subsequently, Manuel Dulay and private respondent spouses Veloso executed a memorandum to the deed of absolute sale, giving Manuel Dulay within 2 years to repurchase the subject property. Now, private respondent Maria Veloso, without the knowledge of Manuel Dulay, mortgaged the subject property to private respondent Manuel A. Torres for a loan of 250,000 pesos. Now, upon failure of private respondent Maria Veloso to pay private respondent Torres, the subject property was sold to the latter as the highest bidder in an extrajudicial foreclosure sale. Private respondent Maria Veloso executed a deed of absolute assignment of the right to redeem in favor of Manuel Dulay, assigning her right to repurchase the subject property from private respondent Torres. As neither private respondent Maria Veloso nor her assignee Manuel Dulay was able to redeem the subject property within the 1-year statutory period for redemption, private respondent Torres filed an affidavit of consolidation of ownership and issuance of writ of possession against Veloso and Manuel Dulay. Manuel Torres filed a case against the corporation and tenants of Dulay Apartment for the recovery of possession, sum of money, and damages. Now, Manuel Dulay Enterprises contended that the sale of subject property has no binding effect on Petitioner Corporation as Board Resolution Number 18, which authorized the sale of the subject property, was resolved without the approval of all the members of the Board of Directors, and said Board Resolution was prepared by a person not designated by the corporation to be its secretary. Now, the issue number 1. Whether or not the board resolution is valid, even if not approved by all members of the board and not prepared by a corporate secretary. Yes, the board resolution is valid. Now, According to Section 101 of the Corporation Code of the Philippines, when board meeting is unnecessary or improperly held, unless the bylaws provide otherwise, any action by the directors of a closed corporation without a meeting shall nevertheless be deemed valid if, before or after such action is taken, written consent thereto is signed by all the directors, or all the stockholders have actual or implied knowledge of the action and make no prompt objection thereto in writing, or the directors are accustomed to take informal action with the express or implied acquiesce of all the stockholders, or all the directors have expressed or implied knowledge of the action in the question, and none of them makes prompt objection thereto in writing. If a directors' meeting is held without call or notice, an action taken therein within the corporate powers is deemed ratified by a director who failed to attend, unless he promptly files his written objection with the secretary of the corporation after having knowledge thereof. In the instant case, petitioner corporation is classified as a closed corporation, and consequently a board resolution authorizing the sale or mortgage of the subject property is not necessary to bind the corporation for the action of its president. At any rate, corporate action taken at a board meeting without proper call or notice in a closed corporation is deemed ratified by the absent director unless the latter promptly filed his written objection with the secretary of the corporation after having knowledge of the meeting, which, in his case, petitioner Virgilio Dulay failed to do so. Now, issue number 2. Whether or not the sale of subject property is valid even if not consented by all board of directors. Yes, the sale is valid. Appellant Virgilio Dulay protestations of complete innocence to the effect that he never participated nor was even aware of any meeting or resolution authorizing the mortgage or sale of the subject premises is difficult to believe. On the contrary, he is very much privy to the transactions involved. To begin with, he is an incorporator and one of the board of directors designated at the time of the organization of Manuel Dulay Enterprises Incorporated. In ordinary parlance, the said entity is loosely referred to as a family corporation. The nomenclature, if imprecise, however, fairly reflects the cohesiveness of a group and the parochial instincts of the individual members of such an aggregation of which Manuel Dulay Enterprises Incorporated is typical. 4/5 of its incorporators being close relatives, namely, 3 children and their father, whose name identifies their corporation.